very sorry I can't be. I'm sorry I can't be with you in person. I would, of course, have loved to come to Thessaloniki, but I'm at least happy that I can talk to you over Zoom. Now, please bear with me in the sense that if you have any questions, please don't hesitate to ask them while I'm talking. It's just that I hope that I'll somehow get a hand or a notice by someone, because I might not be able to see it. So don't hesitate to interrupt me or anything like that. Otherwise, I hope there will be some time after the talk to answer questions and go into some debate if you want. I thank Johannes for his very kind and generous introduction. You'll see here, of course, the two main functions that I enjoy currently today, being an academic on the one hand and a practitioner on the other hand. And as requested by Professor Glavinus as well, I'm going to talk about the military uses of outer space, what laws are applicable, which is, of course, given the current geopolitical situation, unfortunately, a much more important issue than it seemed like it was a couple of years today. Now, as a lawyer, I always think it's important, in particular, if you talk about these complex subjects, to at the outset define some of the key terms. What are we talking about? And this is where I will start. If I can get the thing to get going here. I apologize for that. There we go. So what are we talking about? Definitions, I think, are a key element in all legal discussion. And it is therefore important also in this context of the military use of outer space, of trying to delineate at least what I will be talking about, and you may have different definitions, different impressions of certain terms, but at least then you know where I'm coming from. For example, if we talk about military uses of outer space, some people may inherently think about a war in space, and there may be these fancy conceptions of people shooting laser guns, and some of you may have seen science fiction movies like Star Wars and things like that. But we have to be careful there, because if you talk about the legal issues, war as such is already no longer much of a relevant legal term. In the old days, there was indeed something called a war as a specific legal situation. And as you go back to, for example, the First World War, this is clearly a notice in a newspaper in 1914. There was something like an official declaration of one state to another state. From now on, we are at war, which then triggered into operation a special set of rules in the relationship between those two countries. War trumped many existing legal obligations between the two countries. Trade relations could be broken off validly. And of course, it specifically, unfortunately, justified the use of a lot of armed force. Now, the term war is no longer often applicable. I see someone in the chat and see whether that's a question.
No. If there is, I will let you know.
Okay. Thank you for that, Johannes. Okay, so war is no longer that much of an issue as a legal context, because we now tend to think about the use of armed force and all the unfortunate killing and destruction that goes with it in a broader sense as just between two sovereign countries. One very unfortunate example going back to today's world is, of course, that we don't have an officially declared war between Russia and Ukraine, partly because Russia doesn't recognize the Ukraine as its own state, although there's a lot of unclarity. There was just a sudden invasion a little over a year ago. And many people in Russia still refer to a military operation as opposed to a war. So it's important to realize that the legal term of art that we will be discussing today is the use of force. And this is also the term which, of course, is very much used in the UN Charter as a key document, which we will see pop up a couple of times. The use of armed force, or even just the mere threat thereof, is seen as a most unfortunate phenomenon in international society that, of course, states and populations should do their best to try and minimize, or probably, if possible, extinguish from the earth, although that's probably a little bit of a utopian situation. Now, the use of force is not the same as military activities. Military activities is a much broader concept, and I will come back to that in a moment. And of course, today we will be talking about military activities in outer space, which brings a so-called body of space law into the picture as well. What we are going to talk, as I said, is the military use of outer space, and that brings in basically two different systems of law. I will come back to that in slightly greater detail, but as I said, we should define what we're talking about. So if we talk about military use, it is not just the use of force. The military use of anything, any tool, any operation, any activity is probably best defined in opposition to other terms like civil and commercial. And this applies to space activities as well. They are usually either of a military character or of a civil character, which is still the government doing things, but they have no military component or no military use. And then beyond that is what we would call, certainly in the United States, commercial, which is essentially private use of outer space. Of course, we now have a lot of private corporations which make a lot of money by operating in space. Not always, sometimes they don't make that much money, but at least they try to. So military is best delineated in opposition to civil and commercial. And if you look at definitions of military, it's probably fair to say, and this one is just one picked off the Wikipedia, I confess, but you can find similar definitions in other very important and authentic treatises or handbooks. So it's anything that relates to or is characteristic of soldiers or armed forces. So it is not just the arms or the soldiers or the fighting of the arms, it's much broader than that. And I think the best way to sort of picture that is that we have something called all military activities. And from a legal perspective, they are important because they are not civil and they are not commercial activities, but they are much broader than just the use of force. Military activities in outer space include, for example, the use of satellites for reconnaissance, or if you want to use a popular term, spying. I'm saying a popular term because in international law, spying is not a legal notion. There is no treaty which prohibits spying as such. And as we shall see, general international space law certainly allows the use of satellites for trying to find out what a potential opponent in war, in a worst case, or in a military conflict, is doing about is doing basically in order to determine your own strategies and tactics. So military activities has nothing to do automatically with the use of force. It can be a much broader element. Then there are activities which involve arms. And if we talk about the law, there is a lot of law which addresses things like arms control or disarmament. And we've seen a long period in global history, starting in the late 60s, when the two superpowers of those times, the Soviet Union and the United States, were able to agree on treaties which limited and to some extent even eradicated the particular use of arms. So there is law which addresses all military activities, there's law which only addresses the activities involving arms, and then within that a yet smaller subset is the activities which actually involve the use of arms, the use of armed force. That is what I will largely focus on. So even though we will talk about the military use of outer space in a broad context, what is most worrisome in many respects is, of course, once we actually start using armed force, because that's when there's a conflict That's when there is war, maybe not in a legal sense, but at least in a sense of the use of arms with all the bad consequences thereof. Now, when we then transition to outer space, we should, of course, try to define it. And it's probably obvious that outer space is, in a general context, the realm above or beyond the Earth's atmosphere. Everyone probably knows that there is a lot of air above every country in the world and also above the oceans. That is considered airspace, which has a totally different legal regime, which we will come to very briefly in a moment. And outer space is somewhere where there is no atmosphere at all. I should say in advance that if you ask a scientist where to draw the line, there is no clear-cut answer. This is just one of the many pictures you can find on the internet, which tries to explain the various layers of the atmosphere. And of course, basically, the higher you go, the less atmosphere there is, the less air there is, but there is no specific line, no specific altitude at which you can, in an objective manner, say, well, here we move from an area where there's a lot of air to an area where there is no air at all. Even the figures in this, the numbers in this slide are somewhat arbitrary. If you talk about 85 kilometers, sometimes it's 82, sometimes it's 89. There is no distinct specific line. It is a very gradual process. The further away you go from Earth, the less air there is. I don't know if any one of you is a mountain climber, but then you're certainly aware that if you go to Mount Everest, which is only 9 kilometers high or close to 9 kilometers high, you already basically need artificial air to breathe, because the air is normally too thin to breathe for normal human beings. Now, of course, that is not satisfactory to lawyers and from a legal perspective. And why that is, I will come to shortly, but you can imagine that states and other operators want to know if airspace is subject to one regime and outer space should be subject to another regime, where is the boundary? And we don't want a vague line, we want a specific boundary. Those of you who are familiar with the law of the sea are certainly aware that once you go offshore, there's a first zone called the territorial seas, where we have now, as an international community of states, agreed that 12 miles offshore is the furthest which the territorial waters can extend, and that's basically where the sovereignty of national states end. And then beyond that, you have some other zones, and the treaties on the law of the sea specifically provide you with numbers on where they end and where they start. We have no such thing in outer space yet. You may have heard of a discussion on that, which is recently more appropriate and important, because there are a number of private operators who sell seats on private tourist flights, and they tell you that you will become an astronaut because you will fly to an altitude of a little over 100 kilometers. But I must be very clear that 100-kilometer line, or 62.5 miles, as is also used, is just an informal boundary. It is not recognized as the official boundary of outer space. So far, that probably was not too much of an issue. You can probably say that there is a zone between something like 50 kilometers and 150 kilometers, where it doesn't really matter exactly yet where the boundary is. Of course, unless you are one of those people paying $250,000 to fly to 105 kilometers, and you want to make sure that you can come back and tell everyone else you are an astronaut. But other than that, if you look at the altitudes that I give here, below 50 kilometers is where you still find basically enough air for aircraft to be able to fly around. And above 50 kilometers, only very special aircraft can fly, and usually for only short moments. And they often need things like rocket motors. Whereas if you take the other side, the 150 kilometers, most satellites orbit around the Earth and make orbits around the Earth at least that altitude. There are relatively few who can sort of continue to orbit below that altitude, because if you go below 150 kilometers, already the atmosphere gets a little bit thicker, and you run the risk that the few molecules of oxygen that are there slow you down so as to make ultimately bring you back to Earth, because then gravity starts pulling heavier and heavier. So in the zone that you see here, there are very few aircraft flying and there are very few satellites flying around. So the distinction between the two has so far not really been necessary to establish, but I think that changes. We will focus, obviously, on whatever is above the yellow zone, and in practice it is essentially also above 100 kilometers, although again I have to warn you that is not yet an official boundary. So when we talk about the military uses of outer space, and we have now more or less defined military uses in outer space, at least as far as we can legally go at this point, then of course it will be immediately clear that when we talk about the legal issues, we talk about international law. If we talk about military uses, even though there are many conflicts today which engage non-state actors, whether we talk about guerrilla or freedom fighters or even terrorist groups against other terrorist groups or guerrilla fighters or against states, most international conflicts, one way or another, involve states, more than one state. So it is logically interstate law, international law, which has to try and limit the uses of outer space for the good of humankind. Also, outer space, as from the other angle, as you can imagine, is something which is logically considered to be very international. We will see some examples later on, but it is already clear that outer space doesn't know any national borders, certainly no obvious national borders, which means that if we want to impose some rules for the benefit of all humankind, we should do that on an international level rather than one state or the other on its own declaring this is the law and everyone has to accept that. So also in the overlap of those two areas, we will see that it is international law which is ruling the day, and that's basically what I'm going to talk about, although we should always keep in the back of our minds that in international law, the individual translation of, in particular, major countries, major states, major powers of international law into the national context may be relevant for international law as well. In particular, if there are on the international level general concepts or notions or principles which are broad or vaguely formulated, then we often need to look at how leading states have interpreted that in their domestic law to give us a sense of what it really means. And sometimes, of course, these interpretations can be very conflicting. Obviously, if there is a conflict between the United States and the Soviet Union, or today also between the United States and China on how to treat space, that will lead to conflicting interpretations. And that's where we are still stuck with the problem. Okay, so when we agree that we are going to talk mainly about international law today, then I mean actually international law is of course public international law, interstate law, internation law. We are not going to talk about private international law. We're not going to talk about international contracts between private operators. And then we have one body which is basically applying to activities in outer space. I call that with a Latin phrase, ratione geographiae. It is sort of bounded by the fact that these activities concern outer space. They are taking place in outer space or relevant to outer space. And that is what we call basically with the shorthand outer space law, or space law as the term that I will use from now on. So there is already, as we shall see later in somewhat greater detail, a body of outer space law, which very much focuses at the public international law level on activities in outer space. We similarly have a public international law body which doesn't focus specifically on areas, but focus on a specific substance, a type of activity. That's what we call the law on the use of armed force, often abbreviated LOAC, law on armed force, law on armed conflict, which is another body of public international law. And what we are going to talk about today is basically the overlap of these two. So we have to be aware that when we talk about military activities in outer space, and certainly when it comes to armed conflicts in outer space, there is an overlap of outer space law rules and law of armed conflict rules, and that basically leads to a lot of problems. Now, before we go into somewhat more detail, we should realize that until fairly recently, this was not so much of a problem. Outer space was very much way out there, and except perhaps for a few science fiction writers, there was nobody who really talked about wars in space. Luckily, that is still not the case, but we have seen, so it was not much of a problem for a long time, but what we now have seen already since 20 years is that space has contributed to warfare on Earth. Often the Gulf War of 3 decades ago, when a US-led international coalition invaded Iraq in order to punish it for invading Kuwait, sanctioned by the UN Security Council. This war, at least the US side, the allied side of that war, was very much helped by satellite reconnaissance and satellite communications. So there were satellites who were contributing to the war on the ground. But thereby, it still is a war on Earth, and space only played sort of an auxiliary role, a supporting role to the armed conflict on Earth. And in that sense, it still didn't require the actual implication of outer space law. Outer space law is, as we shall see, premised on the freedom of activity. And there was not much else in outer space law, so it was just LOAC which ruled the day. Again, this was not much of a problem from a legal perspective. That, however, may now change, unfortunately, even further. We have now seen recently a lot of interest resurging in the moon. You may have heard of the US-led Artemis project, whereby NASA intends to put a first woman and a first non-white person on the moon as part of a much broader project to start long-term habitation of the moon, including exploitation of lunar resources. By now, more than 20 countries have joined that because they want to be partner to that American approach. But as you can imagine, not everyone is equally happy with a US-led initiative, and in particular, China and Russia have already declared that they will undertake their own projects, which also from their part, although I haven't seen any details yet, will certainly include a huge interest in the resources that the moon could deliver. Think about water, which is kind of the gold of outer space, or valuable minerals. So with that said, the risk of an actual conflict in space about space resources, about valuable sites on the moon becomes, unfortunately, no longer an unrealistic opportunity. And not just the 3 powers that I mentioned. In addition, India is also becoming more and more assertive in its policy. It used to be very much focused on its needs as a third world country, but it also now wants to have a military presence, including in outer space. Nobody knows what's going to happen to Japan, even though currently they are very peaceful. So unfortunately, the risk of a real space race about economic resources is becoming more realistic than it used to be. I would say for the time being, we shouldn't lose a night's sleep on that. It's still not something which is around the corner, but it's at the same time, we should take it serious. And that, of course, raises the issue of what law would apply if such an armed conflict, for example, over resources on the moon, would break out. For the first time, the threat of an actual armed conflict in outer space, about things in outer space, looms. And that means that we have to go back to this overlap, which now suddenly doesn't become so innocent or irrelevant anymore. We really should question what is in there. Now, the way I'm going to approach this, and that comes basically from this slide, is realizing that there are these two bodies of public international law, which from a different angle, outer space law focuses on everything that happens in outer space. The law of armed conflict happens on anything that contributes to an armed conflict or is part of an armed conflict, regardless of where it takes place, but they overlap in outer space. And then to analyze what is going on there, first of all, from these two angles. So I will first of all address outer space law. What does it say about, what does it not say about armed conflicts in outer space, or even broader, the military activities there? And then do the same analysis from the other side. What does the law of armed conflict have to say about armed conflicts in outer space? We know that it has a lot to say about armed conflicts on Earth, whether it's on territory or on the high seas. But what does it say about outer space? So that's where I will start with the second part of my lecture. Outer space law, and again, we should define that. This is kind of the definition that I usually adhere to, so I take a very broad sweep. It's all the law which is somehow of major and direct relevance to space activities and their major applications. It is not just, some of you may be familiar with that already, it is not just the Outer Space Treaty and some UN treaties, but for example, the International Telecommunication Union has, since the 19th century already, it's one of the oldest intergovernmental organizations, addressed the international use of radio frequencies. As soon as radio stations started to broadcast across boundaries, the ITU came in to help organize that in a peaceful way. Mid-19th century, of course, nobody thought about the possibility that satellites would become part of a telecommunications network. But once they did, roughly a century later, from the late 1950s, that became a distinct possibility. It was clear that also the use of frequencies by satellites would require organization, coordination through the ITU. So to me, the ITU law is part of space law to the extent that it addresses satellites. That's just one example. When I talk about these issues, I'm always reminded of a famous headline in the New York Times of more than 10 years ago. It says, wherever you go, the taxman goes. And the idea was, of course, that wherever humans start being active, the taxman follows them in order to tax whatever their activities may bring in terms of money. Now, I put it to you that actually this should read, wherever you go, the lawyer goes. Wherever humans start being active, the lawyer goes and the law follows, because there is a need to somehow organize, hopefully in a peaceful manner, what these humans are doing. And this is not really different for outer space. This also means that outer space law became an issue only for real once humankind started to do something for real in outer space. And of course, the key moment there is Sputnik. In 1957, the Soviet Union sent up this small crystal ball, sorry, not crystal, it was metal, of course, which did nothing more fancy than beep, beep, beep. But it was the first proper human activity in outer space. It orbited the Earth a number of times. And if you look at the orbit, at the trajectory, you can immediately realize that it raised the first important legal issues, because the Soviet satellites orbited a number of times over US territory. And of course, in 1957, there was a Cold War between the Soviet Union and the United States going on. And both sides were afraid that that might enter into an actual nuclear war. And if Sputnik showed one thing, it showed the Soviet capability of also dropping a nuclear bomb on the United States. So you can imagine that this raised a lot of legal issues. And the first important discussion almost immediately took off. What is the legal status of the area where this satellite is orbiting? Can it indeed orbit? Can it overfly basically an enemy country, if you will, although the war was luckily only a cold one, the enemy country of the United States? Does it have a right to overfly that? We should realize that, and this is of course a simplified cross-section of the North American continent, that every country is sovereign over its national airspace. The United States could prohibit anyone from entering US airspace, and if people wouldn't listen, they would, in principle, be entitled to shoot something down. I just need to refer to the recent Chinese balloon, which entered US airspace and was shot down. Now, of course, the Canadians and the Mexicans have their own national airspace. They are sovereign over their airspace. And then I put the Atlantic Ocean there to show that there is also a part of the global airspaces, which is called international airspace, where nobody is sovereign and everyone can fly. But now we have Sputnik. Is Sputnik flying in some different area, which we should call outer space, where the sovereignty of the United States to prevent anyone from overflying US territory does not happen? You can imagine that this was a pretty hot legal potato. And indeed, immediately discussions started. So within the United Nations, a committee was established. You see the date here, 1 year after Sputnik itself, called the Committee on the Peaceful Use of Outer Space, with both the United States and the Soviet Union being very keen on coming to an agreement. Talking about the committee, it consists of today about half of the UN member states. Basically, every UN member state which shows a keen interest will usually be admitted. And they meet annually to discuss issues of space law and propose solutions. Importantly, it's all based on consensus. So there is no majority voting, not even on the agenda. It's all based on consensus in order to make sure that the things that happen there, the legal agreements that happen there or that arise out of there are basically agreed to by all states. COPUOS gave rise in 1963 to the first General Assembly resolution. If you know your international law, you may recall that General Assembly resolutions as such are not legally binding documents, but they are, of course, authoritative political statements and at least provide a point on the horizon for states to aspire to. So they are still leading, in many cases, to actual international law. That also happened in this case because most of the elements of the resolution in 1967 were translated into the Outer Space Treaty. That's the short name. I won't bother you with the long name, but it is the fundamental treaty encompassing all the baseline rules for outer space. And everything else basically was built upon that. To give you an idea of the importance, about 113 states are parties, which is more than half of the states of the world. There are 23 more signatories. Those of you who are familiar with the Convention on the Law of Treaty, the Vienna Convention on the Law of Treaty, know that if you are a signatory to a treaty, even if you have finally honor what the treaty says. So very importantly, this treaty is also including all the major spacefaring nations among the 113. Greece is also among them, but also all the superpowers. So you can really say that this provides the legal framework. In addition, it is generally considered customary international law, meaning that even those 80 or so states which have not ratified it, which are usually poor African or Pacific Island countries, which so far have not considered that space is something of interest to them, even they would be bound to it once they start operating in outer space. Some of the elements of the treaty had to be elaborated. So in the following years, you see 3 implementing treaties. One treaty is the Rescue Agreement, which talks about the rescue of astronauts. There's a convention which specifies the liability arrangement. If somebody causes damage in outer space, this convention elaborates the fundamental principle which was already there in the Outer Space Treaty. And then we have a 1975 registration convention, which asks for registration of space objects in order to allow identification and also, in a sense, promote some level of transparency of what's going on in outer space. So from this origin, we see a number of general principles arise, which I will go through shortly to give you a general idea. And then we will also zoom in on what the outer space law, and in particular the outer space treaty, have to say about a real subject, the military use of outer space. The most important article, I think, is Article 2, and that's why I quote it in full. It says that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty or by any other means. And if you are not really certain what that means, well, if you look at history, in particular, Western European countries had the habit of going to other parts of the world, which they considered uncivilized or even uninhabited. They planted their flag there and they said, now this is colony of the motherland and we determine what's going on there. Now, of course, since the UN Charter, colonization is prohibited, and actually on Earth, we've seen a major rollback because most of those countries have now become independent, particularly in the 60s and 70s. And Article 2 basically says it is now prohibited in outer space too. So both the United States and the Soviet Union agreed that there would be no legal colonization of outer space. Human habitation is a different thing, but it cannot mean that, for example, the moon could become part of US territory, even though, as we all know, I guess, the US planted a few flags there when the Apollo astronauts landed there in the late 1960s and early 1970s. The US actually went out of their way to say, well, this is a small step for a man, a giant leap for humankind. It's not just for the United States, and we come on behalf of all humankind. And they were very clear, we do not claim part of the United States. Linked to this general absence of sovereignty in outer space, we have an article which provides that freedom of activity as a consequence in this international area is the legal baseline. And limits to that freedom can only be imposed at an international level. So if states agree to treaties or customary international law, that's how they accept limitations to their freedom. This also goes back to the famous Lotus case, whereby the Court of Justice of then the League of Nations declared that you cannot simply assume a state to be subject to an obligation. You need to point at a specific rule for it to do that. A third principle, which I will come back to later, is already posed in Article 5 of the Outer Space Treaty and then further elaborated in the Rescue Agreement, and it gives astronauts this lofty title of envoys of mankind. This should not be taken to refer to a diplomatic status in a legal sense. It just means that these people should be considered to risk their lives for the benefit of all humankind. So if they are in distress, they should be helped and they should be repatriated and not be kept as spies. That was kind of the subtext of this provision. Neither the United States nor the Soviet Union wanted one of their astronauts or cosmonauts, if for some unfortunate reason they would land up in the hands of the other, to be then taken as kind of spies and taken prisoners. We have an important principle when it comes to the private use of outer space in Article 6, which basically says that states are also responsible for private activities. As long as they qualify as national, that's the only qualification, then a private activity in outer space equates with a national activity. So if Elon Musk, a famous US entrepreneur, is going to do something on the moon or on Mars, which violates the international obligations of the United States as a state is directly responsible for that. And it is also required by Article 6 to impose national authorization and supervision mechanisms, which usually means national laws. If we would have time, we could play fun with flags, because these are all the countries which so far have established a national space law, which provides for such a licensing regime. And you see there in 2017 that it includes your country, Greece. There is a Greek law which requires any Greek operator to become active in outer space to first get a license in order for the Greek government to be able to live up to its responsibility. And it goes even further than that, because sort of a twin article to Article 6 of the Outer Space Treaty is Article 7, which is then further elaborated by the Liability Convention. And that states that liability for damage caused by space objects also is state liability. So if the same Elon Musk causes damage to a foreign space object, to foreign astronauts in outer space, the victims do not need to sue Elon Musk or his company in a private capacity in a US court. No, the claim can be directly laid at the doorstep of the US government, because for the purposes of international space law, the private activities of Elon Musk causing damage are equated to US activities, which again means that all those countries with these national space laws have included in the licensing agreements arrangements for how to handle that. You can imagine that if the Greek government would license a private operator to do something in outer space, and the private operator then causes $100 million of damage to a neighboring satellite of another country, which means that the bill will then have to be paid by the Greek government in first instance, that the Greek government would have liked to have a tool to go back for that 100 million to the operator or to the insurance company of that operator. And that's why there is a national Greek law to make that happen. A couple of more general principles, which also have an indirect bearing, as we shall see, on the issue of military activities. Article 8 of the Outer Space Treaty, which is then elaborated by registration, by the Registration Convention, requires registration of space objects and then sort of treats those space objects as quasi-territory of a flag state. So it's the same principle that you see on ships, aircraft. I apologize for using the US example here, but they were the clearest example with the flag on a spaceship as well. And you even see the flag waving on the moon, where there is one example of personnel of a spacecraft, which strictly speaking is not on the space object at this particular moment of the photo, but still falls under the quasi-territorial jurisdiction. The last general principle I would like to refer to is Article 9, which is unfortunately a weak article because it merely requires due regard for the interests of other states, which by now are at least leading to international guidelines on trying to prevent space junk from occurring. Space debris is the technical term of art for space junk, but we are still not in a situation where countries are prohibited to create more junk in outer space or obliged to create their own junk. That is something that we still need to work on as lawyers. And I do see some progress, but we are certainly not there. And I should explain that back in 1967, when the Outer Space Treaty was concluded, the whole idea of pollution of the outer space environment was really on nobody's mind. But now we are stuck with a situation, well, it's really as bad as this one. This is obviously an exaggeration, but it is getting worse and it's getting a real problem. Okay, this is so far just a general picture and those of space law, and though some of those principles certainly have an important bearing on the military uses, they have no specific reference thereto. We do have a few principles which actually address military use. I'm not talking yet about the smaller part of armed forces, but military use in general. So Article 3 of the Outer Space Treaty is very important in stating that international law in general applies to outer space. But we should be careful. I mentioned the ITU Constitution, whereas it is specifically provided that military use of space frequencies is not technically subject to coordination. So the military of individual countries can use whatever frequency they want. They don't have to go through the ITU process, even though in practice they will follow it, because this is essentially a little bit of a lucky side. If you have two radio sources broadcasting on the same frequency, both have white noise. So it's in the interest also of military operators of space frequencies to seek out the frequencies where they are not interfering with someone else, because it almost automatically means that the other party is also interfering with their use. But that's a practical matter rather than a legal matter. Space activities under the same article are specifically required to promote international peace and security. And then we have a few more general articles. We have Article 4 of the Outer Space Treaty, which when it comes to outer space as a whole, only prohibits the orbiting and the stationing of weapons of mass destruction in outer space. Unfortunately, this is only a very weak limit on the military use of outer space. It specifically does not prohibit two things. One is anything which is not a weapon of mass destruction. Some of you who are somewhat older may recall that the Reagan administration in the United States had plans for a laser-based weapon system in outer space. Star Wars, it was called. Officially, it was the Strategic Defense Initiative, SDI. And the discussion was then, are laser beam weapons weapons of mass destruction, in which case they would be prohibited to be launched into outer space and stationed there, or are they normal weapons, non-weapons of mass destruction, in which case they would be allowed? Luckily, we never had to answer that question because the project remained on the drawing board, but it gives you an idea of the limitations of this article. And the other thing which is not prohibited is the use of outer space as a trajectory for nuclear missiles. And again, if you look at the political reality, that's only understandable because neither the Soviet Union nor the United States would have ever underwritten a treaty which prohibited them to use their intercontinental ballistic missiles, because from their respective security strategies, ICBMs were a core part of their security defense. So unfortunately, Article 4 in the first sentence doesn't go very far. In the second sentence, when it comes to the actual celestial bodies, like the moon and Mars, luckily we have a much more stringent limitation, because basically all military activities are prohibited. Then there are two articles which are kind of providing for transparency and confidence building measures. That term didn't exist in 1967, but states were entitled to observe within certain limitations the launches by other states to ascertain themselves that it was not a missile which was launched, but a peaceful rocket, and the similar right applied to stationary celestial bodies to check out that they were not secretly military stations on the moon.
Professor,
Then,
may
yes.
I interrupt you? There is a question in the chat. Would you like me to read it for you, or?
I'll open the question. Dear Professor, I recently read an article in which it mentioned that Elon Musk gave access to the Ukrainian armed forces in order to use his Starlink SIM for military purposes. Is this use legal or illegal? And if it is illegal, are there any consequences for the US? That's a great question. And the baseline answer to the first part, it is certainly not illegal. It goes basically back to the baseline freedom of Article 1 of the Outer Space Treaty, that states are able to do in outer space what they want. And because of Article 6, as long as they properly license Elon Musk, which in this case the US has done, his Starlink operations need a license from the United States, and they have been given the United States. By these licenses, they can also allow Elon Musk to enjoy the freedom of outer space. So as long as there is no specific treaty obligation resting upon the United States, which prohibits it to allow Elon Musk to allow his system to be used for military purposes, that is okay. It is legal. What is a slightly different question, and with your permission, I will come back to that at the end of today, is the question whether this might lead to a change of the status of the United States from a neutral country to one of the belligerents in the armed conflict. And it may mean that once you would argue that as a consequence of the scenario that you sketched, you are changing from a neutral country to a belligerent, then of course it would entitle the Soviet Union, Russia, to take measures. I don't think that's the case. I will come back to that later. There's a second question: is it legal for a country to target and engage a spying satellite? Yes. And actually, it goes even further. In a couple of disarmament treaties back in the 70s between the Soviet Union and the United States, it was specifically accepted that the other states could use satellites for monitoring that its opponent would actually comply with whatever was agreed in those disarmament treaties. So there's even an explicit recognition on the part of the Soviet Union and the United States that satellites were useful and were legitimately used for controlling each other, for making sure that the other party was not cheating. That was part, it depends on it, it's a great question, is this subject of LOAC or the law of outer space? It depends a little bit on how you define it. What is certain to me is that it belongs in that middle part. And luckily, this is a very clear role. With your permission, we will come back to this discussion because there are a few more angles to that later on.
Okay,
So,
thank you very much. Would you like to take maybe a 10 minutes break or?
okay, if you want to, yes, sure.
Maybe, okay.
Yeah,
So
let's
have a
10
break.
minutes, yeah?
Exactly, for 10 minutes. And we'll be back.
Yeah, okay. For myself. Okay, so as you can already see on the screen, when it comes to the actual principles zooming in on armed conflict, there's just one article which applies. And it goes a little bit back to one of the questions, is this law of armed conflict or is this space law? It is actually both, because what Article 3 does is import the UN Charter. At least in principle, we will see that there are some complications when we actually look at the details. But at least in principle, it imports the UN Charter as part of outer space. So the fact that there is a baseline prohibition of the use of force against the territorial integrity or political independence of a state under the UN Charter may also means that you cannot use force from space against the territorial integrity or political independence of a state. What that means for the use of force in space, which we are now discussing, we will see in a moment. But obviously, states have the right to defend themselves. The right of self-defense is a key part of the UN Charter. And if the self-defense includes space assets, that is certainly possible. So going back to an earlier question, if the Ukraine wants to defend itself using the services of a US operator who offers them for free or for a cheap rate, then that is fully part of its entitled right of self-defense. The other exception to the prohibition on use of force, the other exception which is generally accepted, I should say, is of course if the UN sanctions the use of force. I've given the example of the US allied coalition against Iraq more than 3 decades ago. And of course, if that is allowed, then it is also allowed to use space in support of such use of force. Article 3 does not just refer to the Charter, it refers more broadly to international law, so also other treaties on armed force, by that token, are sort of imported into outer space. And I'm going to give you just 2 examples. One is the Partial Test Ban Treaty of 1963, which prohibits any nuclear explosions in outer space, which already by its own terms refer to outer space. But there's also something like an environmental modification convention, which prohibits the use of environmental modification techniques of armed conflicts. And that, through Article 3, is also imported into outer space. But unfortunately, that is basically all that space law as such has to offer on armed conflicts or military uses. And the problem here is that outer space law was sort of assuming peaceful use of outer space and reflecting a hope that these uses will continue to be peaceful. So while there is a major effort to minimize the chances of armed conflicts in outer space, there is nothing specifically on what happens if an armed conflict actually breaks out. And then, of course, the elephant in the room, oops, that takes a little bit. I don't know why. Come on. What's going on here?
Maybe it's the elephant.
It's the elephant, yeah, which takes a long time. Well, maybe it will pop up, but the elephant in the room is basically that the possible future reality of actual armed conflict is ignored. Well, let me stop sharing for a second and see whether I can get back to this.
Okay.
Somehow, I don't know what's happened. Now I'm not sharing anymore, am I?
No, you are not.
Okay. Oh gosh, something is really interfering with it. Okay, well, I'm afraid that unless this section, you can still hear me, right?
Yes, exactly.
Yes. I'm afraid I'm going to have to do it without slides. I don't know what's interfering here. But as I was about to say, or maybe I did already say it, the possible reality of armed conflicts is not dealt with. So that's why when we have to look at the unfortunate possibility of armed conflicts in outer space, then look to the other side of the equation, the law of armed conflict. And of course, we should realize that the law of armed conflict comes from a baseline obligation to limit the disastrous effects. Johannes, may I propose that I get out altogether and then log back in?
Yes, you
Because
can.
I think it's more useful for the students if they can actually see the slides.
Yes, you can log out if you want.
Yeah. Okay.
We're here to.
I'll do that. So please stay on. I'll try to get out of
Okay.
this, and then I'll be back in a few minutes.
Okay, that's okay.
Simply been taken, has simply not been taken into consideration. So that's why we need to take then a look at the law of armed conflict to see whether they can help us there, because obviously the law of armed conflict accepts that there is an unfortunate reality in the world of armed conflicts. And I apologize for the elephants. You clearly see that that's one of my favorite animals. And the idea is to limit them at least, and to limit their disastrous effects. I think in one sentence, that's what the law of armed conflict is all about. So if you want to have a definition, it's all law, it's a bit similar to the definition of space law. It's all law of major or direct relevance to armed conflicts, when or wherever and however they may be fought. And contrary to the outer space law, which is still relatively succinct and you can easily spell out what it is, the law of armed conflict, because of its age-old existence, comes from many elements. Probably you are familiar with terms like the right to get into war, the legitimate use of force, the jus ad bellum. And once you are in a use of force situation, what rights you have as a belligerent or as a neutral. And also international humanitarian law, but there are also specific regimes such as the law of neutrality, the law of prizes, the law of targeting, which are part of that. And then we have a whole other category, which to me also is the law of armed conflict, is the exclusion of the use of certain categories of weapons, or even the total exclusion of the possession thereof to start with. I'm going to give some examples later on, but this is just a kind of an introductory list. So the result is also that you have many sources. You have famous series of conventions around the year 1900 in The Hague agreed on what is proper in war. We mentioned the UN Charter, which is clearly a keystone, a milestone in the history of the law of armed conflict. We have Geneva Conventions and Protocols. We have many more treaties, often with a special focus. And because there is so much, unfortunately, so much state practice, there's also a considerable amount of customary international law. So let me now try to take the same approach, and before we again hone in on the overlap in the middle of my diagram, the armed conflict in outer space, set out the general principles, and then the general principles to the extent that they might apply to outer space in particular. So general principles, and I really take a bird's eye view here, is to try to limit the use of armed force in an international context. St. Augustine already spoke about something like a just war, which obviously means that there are also unjust wars, and only just wars are allowed, a specific context where the use of force is allowed. And I think it's fair to say, even though it's a little bit shorthand, it's a little bit black and white, that there are only two fundamental exceptions of the use of force, and we discussed them already in self-defense, particular as drafted by the UN Charter. There is some discussion whether it goes beyond the Charter, but as far as the Charter is concerned, there clearly is a right to use force in self-defense. And then the other use of force is when the UN itself, through the Security Council, sanctions or even requires the use of force. This is still traditionally very much applicable to states and their armed forces, although, of course, in the last half a century, we see more and more discussions to what extent the use of armed force by or against individual non-state actors is justified as well. Whether you call them terrorists or freedom fighters is another issue. Another principle is the limitation of the use of specific arms and the methods of using armed force. We have famous things like the Biological Weapons Convention. I already mentioned the NMOD Convention. There's also a Chemical Weapons Convention, which basically prohibits the use of chemical weapons because they cause unnecessary suffering. Again, a limitation of the trying to limit as much as possible the bad inhuman effects. Of the use of force, and some things like the Anti-Personnel Landmines Convention. What is very important, and we will come back to that later also in the case of outer space, is that there is a fundamental distinction between those who actually wage the war, who are fighting against each other, and the rest of the states who are basically neutral. So you have two fighters or more, but there's two fighting sides, and the rest of the states are basically, in principle, neutral. And lots of rules in the LOAC, in the law of armed conflict, determine the rights of belligerents, what they can do vis-a-vis neutral states, and what rights neutral states have to stay out of the conflict. We'll come back to that in greater detail because this is a key feature of my discussion. Then we have protection of various categories of persons involved in conflicts, like combatants. Once you have them out of a fighting mode, you can't just kill them. They should be taken prisoner of war, and prisoner of wars are entitled to a certain level of humane treatment. And of course, when you go outside of the combatants, you have to be even more careful. There is no absolute prohibition on killing citizens, whether of belligerents or of neutrals, because that's an unfortunate side effect, but you can't just indiscriminately kill them. And the only justification for them dying is if it's part of an accident or collateral damage, and then there are rules of proportionality. So in principle, the right to kill just persons because they belong to an opponent is very, very limited. There's a protection system for various categories of assets as opposed to person. Think about hospitals, non-military targets like food markets, and non-military assets like medical supplies, food supplies, and things like that. Now, the elephant in the room here is that the absence of armed conflicts in outer space so far, which is a lucky thing, has meant that the law of armed conflict has very much focused on 3 traditional domains, and there is no straightforward application thereof to the law of outer space. So if you look a little bit more into detail, if you want to apply those principles, well, there's a lot of LOAC which applies to the land, which is ruled by territorial sovereignty, where the distinction is mainly between the territory of one belligerent versus a neutral state. If you have war with one other state, you can't simply use the territory of a neutral state as part of your military campaigns. The neutral state has a right to remain free of that kind of military invasion. Think about what Germany did in the Second World War when they invaded countries who had declared themselves neutral. That was certainly not appropriate. There are similar rules, and to give you one example, the 1907 Hague 5 Convention specifies that in great detail. There are a lot of rules in LOAC on the maritime sector, which is split in between territorial seas, where territorial sovereignty again rules similarly to land. So the main focus is on the areas where there is no territorial sovereignty, the contiguous zone and the high seas. And there it addresses, for example, things like the sovereign immunity of warships, which cannot be accosted by any neutral state, for example. These things are provided by the Hague 13 Convention. And then we have a similar thing when it comes to the airspace above, where you have again a mix of territorial sovereignty and the absence thereof. In international airspace, there is no territorial sovereignty. And you have a Chicago Convention, which specifies that countries are sovereign over their own airspace, which also means that a neutral country has the right not to admit the military aircraft of a belligerent country. And that is then also reflected by the UN Charter. But outer space, there is no domain-specific law of armed conflict there yet. And outer space is neither subject to national sovereignty, as we saw Article 2 prohibits the application of national sovereignty to outer space, nor to airspace law, even international airspace law, because it's not airspace, it's outer space. What the best you can say is that there are some law of armed conflict principles which are going beyond domains. They are general principles, not limited principles like the sovereign immunity of warships. You cannot simply say, okay, let's apply sovereign immunity of satellites, something like that. But there are some general principles. So the obligations on armed attack and the rights of self-defense, as we already saw, also apply if these armed attacks involve space forces, or if the right of self-defense uses space. There are general principles of international law, a prohibition on genocide, which also obviously applies to outer space. The fact that no country is entitled to commit genocide also means that you cannot use satellites or space weapons to do so. And then there are, and that becomes a little bit more to the point, some general principles like what they call discrimination or military necessity. Even if you fight an opponent, you're only entitled to try and destroy military objects, which give you a clear military advantage. Even Russia continuously tried to organize that whatever they destroy in Ukraine somehow amounts to a military basis or a military facility. If they cannot argue that, they move on to proportionality and say, well, sometimes things go wrong, but we are entitled to try and hit the Ukrainian military. And if we sometimes miss by a couple of meters, that's just the bad luck of war. That doesn't mean that we are out of bounds in terms of LOAC. So these principles could apply or logically would apply also in outer space because they make a lot of logical sense. But the question is then how they apply. So that brings us back to the question mark. And the problem is now, of course, that we are not just facing a conflict between two opponents when we are going to face an armed conflict in outer space, but it's also a conflict between two sets of law, between two law books. Which of the two regimes will rule that? It's a recipe for incompatibilities, and I'm going to give you 6 examples, and 1 or 2 go back to the questions that were put before me shortly before the break. So the first example is an attack on a satellite. If you look at outer space law, there is no territorial sovereignty, so there is no national territory in outer space, and space objects may qualify as quasi-territory, but that still questions whether you can attack a satellite. On the other hand, the law of armed conflict says that you cannot attack the territorial integrity or political independence, unless when it is in self-defense or the other accepted exception, which is in the context of a UN-sanctioned use of force. So the question is then, does a satellite attack on somebody else's satellite, constitute a use of force against another state, in which case it would be prohibited? Or does it not, because space law tells us it's not territory, it's not another state, it's only the satellite of another state. We'll come to some of the answers or efforts at answers later. I will first set out the 6 examples to give you an idea of the potential conflicts. If you look at self-defense, and it comes a little bit from the previous one, outer space law talks about, again, the fact that space objects are only quasi-territory. The law of armed conflict attaches the right of self-defense against the armed attacks against the UN member state, and in that case, you are entitled to use force. Does it mean that if your satellite is attacked, you have the right of self-defense under the UN Charter? And what would that mean? Could you destroy another satellite in self-defense, or would you be entitled to actually target something on the territory of the opponent state which destroyed your satellite? A third example is damage to a satellite. Now that sounds a little bit trivial, but if you look at outer space law, there's a very clear rule which says that if you damage another state's satellite, you can be held totally liable without limits for the damage caused to that satellite. Actually, it's a matter of fault liability, but you can imagine that if you do it on purpose, it's kind of a super fault in legal terms. So there's no question that if you damage somebody else's satellite on purpose, you have to pay for all the damage, no question. But the law of armed conflict says, well, if assets are used as part of military operations, use of force operations, they may present under the law of war, distinction, discrimination, military target, a perfectly legitimate target for use of force. Does that mean that a state is required to pay for the damage if they destroyed another opposing belligerent satellite? If that's a legitimate target for the use of force, that doesn't seem to make sense, right? And you have to choose between one of the 2 systems. Again, I'm going to keep you a little bit waiting for the solution to that question, to the extent that there is one. And we'll continue with a 4th element. We briefly spoke about astronauts under outer space law, that they are to be treated as these very important human envoys. The formal term is envoys of mankind, and I apologize for that. Back in the days, it was all focused on men. Of course, it should read humankind nowadays. But anyway, the idea is, of course, that they are very special, that they risk their life for the greater good of humanity, for getting more knowledge about the universe and the climate on Earth and things like that, and do all sorts of beneficial experiments there. That's why they should be treated with the utmost respect, and everyone should run to the rescue. Now, the law of armed conflict says if combatants are engaged in combat within the limits of LOAC, again, you can't kill a combatant whom you already have taken prisoner of war, but unless that happens, they present legitimate targets. Unfortunately, wars, use of force, mean that you are entitled to kill the military people of the opponent as long as it's in combat. Now, what does that mean if an astronaut qualifies as a combatant? If you have a military astronaut in outer space and he happens to fall into the hands of another of the opposing country in that military conflict. Is he or she potentially subject to being a prisoner of war? A fifth example concerns transparency. Outer space law tries to enhance transparency to the maximum because of the registration obligation, and by registration of space objects, people know what is out there and more or less what it's doing. But the law of armed conflict generally allows states to try and hide their military activities vis-a-vis the opponent and even disguise them, as long as it's not prohibited. Of course, you can't disguise a military tank as a Red Cross vehicle, because that is making abuse of the Red Cross signal to act as if you're totally acting in a peaceful manner, and in reality you use that as a vehicle for a military attack. But you can cover your tanks with bushes and other sorts of technology if you want, to try and make your enemy not aware of what you're doing. So does that mean that you no longer have to provide any information on military space objects if they could be used for in the context of use of force? So which of the two rules is the superior one? That's kind of the question that we are driving at. The last example talks about the moon. We saw outer space law, again, going back to Article 2, prohibiting any territorial sovereignty. No part of the moon can become part of any state's territorial sovereignty. And actually, as I said, no military activities are allowed on the moon. However, if you look at LOAC in general, it addresses the use of neutral territories, which can, to limited extent under the law of neutrality, be used by belligerents. Now, does that mean that a state who is engaged in a military conflict with another state is still not entitled to use the military facility, or to use the facilities? I shouldn't have said military facilities, but the facilities on the moon, then for military operations, if it's part of LOAC? So, with these six examples, I hope to have given you some sense of the potential conflicts and incompatibilities that arise if you just apply the law of outer space to these specific scenarios, or just the law of armed conflict, and we need to find a solution. Now, we do have in international law a number of general legal concepts which help us doing that. A famous concept is that of lex specialis. The full concept reads that the lex specialis derogat lex generali, and it simply means that if you have two sets of laws applicable to the same situation, the set of law which is more specifically focused on your situation should trump the other law, because it is more specialized, more focused on your situation. Now, the problem here is that both outer space law and the law of armed conflict are, in a sense, special laws compared to the general law of public international law. So it doesn't work between two different bodies of special law. If you look in detail, Article 3 of the Outer Space Treaty makes international law applicable to outer space, as I said before, but only to the extent that outer space law itself doesn't provide clear guidance. The fact that the UN Charter talks about the sovereignty of states over their own national territory doesn't trump the prohibition on territory and sovereign territoriality in outer space of the Outer Space Treaty itself. So clearly, outer space law is a lex specialis compared to general public international law. But the same can be said about LOAC, whereas normally countries are obviously required to treat foreigners with respect. They're certainly not entitled to take them prisoner or kill them just like that. When it comes to an armed conflict, things changes because these foreigners may now be seen as combatant. So unfortunately, this doesn't help us solve the conundrum. Another concept which we often see in these kind of discussions is of the lex posterior, where the idea is if you have a later law, a more updated law, that should trump earlier laws. Now here the difficulty is to qualify, to use this concept in this particular context. I've just given you here a very simplified timeline. You see that in since basically the Roman days, or the Greek, the old days of Greek antiquity, there were already some rules on how somebody was supposed to fight a just war. Customary international law is centuries, if not millennia old. In outer space, until there was any law, you could argue that there was a total freedom. Then you see in the law of war, you see the Hague Conventions, which I mentioned before, you see the UN Charter in 1945, you see the Geneva Conventions, very important in the law of armed conflict, and the Partial Test Ban Treaty, which I mentioned before. And only then you get a piece of space law, the Outer Space Treaty. But that is sort of confusing because the Outer Space Treaty specifically refers back to the UN Charter. And you could thereby argue that the UN Charter also is a piece of outer space law, but it also sort of muddles the lex posterior issue. And similarly, Partial Test Ban Treaty is now part of space law. This gives reference 1968, 72, 75 to some of these other treaties. And then in 1977, we have the protocol. So basically, you cannot use this concept as a way of telling whether it's the outer space law or the law of the armed conflict, part of the rule which should rule. So unfortunately, this concept is of no use. Then there is a third element, and that's a little bit more useful, and that's the UN Charter itself, partly because it's part basically of both outer space law and the law of armed conflict. And it also helps that the UN Charter itself, in Article 103, says that the obligations under the Charter override any other international obligations. So the UN Charter is of a higher status in international law than any other international obligations. And that is already helpful, although we should always see that it is only limited to its scope of application. So what it doesn't do is turn quasi-territory into territory. An attack on a satellite is still not the use of force in the sense of Article 2, Paragraph 4 of the UN Charter. This first conundrum, which I set out a couple of slides earlier. It doesn't mean that you cannot counteract that, but you cannot counteract that on the same basis as an attack on the use of force, by use of force. And it very much depends whether the attack is legitimate or not. So that goes back to one question that was also asked before the break. An attack on a satellite can also not trigger automatically the right of self-defense, at least not under Article 51. It may still be triggering some other form of retaliation. You might be entitled to blind a satellite of an opponent, or maybe a set of satellites, or to blind a ground station. That is still an open question, but the normal right of self-defense to go and use armed force against the territory of your enemy, which has been attacking you under self-defense, is not allowed by the Charter. So it does help us solve some issues. Not 3, 4, 5, and 6. So we have to look further to those. Well, we have some rules of treaty interpretation. We have the Vienna Convention on the Law of Treaties, which in Article 31 refers to manifestly absurd or unreasonable results. So if you have a treaty context, which if you read it literally, doesn't make sense anymore, and you cannot argue that the states parties to that rule would really have meant that rule to mean that, then you can use the reasonable interpretation. And that gives us some solutions as well, because it can clearly not have been the party's intention of signing up to the Liability Convention that you are actually required to compensate damage caused to a space object of another state if that poses a legitimate target under the law of armed conflict. So here you see that the rule of treaty interpretation clearly allows LOAC the right to destroy an opposing belligerent space object, to allow that to supersede the rule of space law, which says you have to pay for the damage. Likewise, the treatment of astronauts as enemy combatants is allowed if they are indeed can be seen as combatant. That's, of course, an important qualification. Not every astronaut of the opposing belligerent can be treated as an enemy combatant. It's interesting to note that in spite of all the rhetorics and sanctions going on between the United States and Russia, they are still cooperating on board of the space station, and the astronauts are still treating each other, astronauts and cosmonauts are still treating each other as cooperators in the same context. So basically here also LOAC, as long as an astronaut can be seen as fulfilling a clear combat-related purpose, can be seen as an enemy combatant, and as a consequence is a legitimate target to be killed or taken hostage. Now, of course, that doesn't solve all the problems, because you could also argue, if that's the solution, what do the rules of outer space law on astronauts of mankind and compensation of damage mean if they are suddenly becoming irrelevant if an armed conflict erupts? We'll come to answer that question soon, but it's clear that the previous one, these rules of treaty interpretation, do not solve that question fully. It leaves us with a feeling of, okay, so these outer space law rules about astronauts and damage do not really mean anything. They can be set aside as soon as an armed conflict erupts. It's luckily not that easy, as we shall see. And there are lots of other rules where the same would apply. The avoidance of harmful interference we talked about, the prohibition of nuclear explosions in outer space. If all that could be simply set aside because the states did not mean to exclude that when they signed up to the Outer Space Treaty, I think that's going a bridge too far. In order to solve that issue, we come back to a fifth concept, and that's called pacta tertiis, which is, of course, a Latin phrase which basically says that if two states agree on something in a legal sense, a third state can never be bound against its will by what these two states agree upon. This confirms the essence of the Lotus principle, that each state has the sovereign discretion and there's only a limited set of rules which are called jus cogens, which are accepted from that rule. But otherwise, states can really determine which obligations they want to accept and they want to sign up to. And I put it to you that this is very much similar to the right of each state, once it is confronted with an armed conflict of two other states, to decide, do I want to be involved? How do I want to be involved? Do I want to be involved with one or the two parties because I think that party is my ally, or that party is on the right side of justice, or whatever the reasons are? Or do I stay away from the armed conflict? And this brings in back the issue of neutrality. So now we're going to focus on this third person. Is he shouting because he is really rooting for one of the two, sponsoring one of the two, hoping that one of the two will win and maybe secretly helping him? Or is he a real neutral and is he just shouting his anger that there is any war going on at all? A third party in the legal sense of the pacta tertiis principle is essentially the same as a neutral state, because in both cases, these states have the sovereign right to decide to what extent they want to be part of it. So let's go a little bit into the concept of neutrality. If you define neutrality, you will find that the Hague Convention talks about the desirability to define neutral, but it then focuses on neutral persons and doesn't give a real definition. Similarly, the Hague Convention 13, which talks about maritime warfare, talks about the relations between neutrals and others, and decides that neutral powers should apply their rules impartially. So impartiality is a main element of belligerence, but it doesn't really define neutrality or the neutral state beyond that fairly general statement. So if the states do not provide us with clear guidance, international law tells us that in their absence, we may look at what experts think. So I'm giving you a few definitions of neutrality. The Merriam-Webster Law Dictionary says the refusal to take part in a war between other powers. That's really very black and white, but it does give the essence. Lieutenant Colonel Wolf, who was one of my former students in the United States, wrote a thesis on that, and he says it's the non-participation in conflict and non-discrimination between the belligerents. So you can stay out of the conflict, but still provide one of the belligerents with all they want and the other not. And in that case, you are not non-discriminatory, so you may no longer be a neutral. And a famous long-term expert, Professor von Heinix, sort of echoes that by saying the attitude of impartiality adopted by third states towards belligerents. So I think it's fair to say that neutral states are states that choose not to participate actively on behalf of either states. And as long as this participation is so, at best, so limited that you can't really call it participation in the conflict, they just still trade with that country, you can call yourself a neutral country. And that's the same with, again, with the pacta tertius principle, which in full reads pacta tertius nec prosunt nec nocent. So pacts by third countries can neither give you any rights nor any obligation as a third state. So state sovereignty allows each state the discretion to what extent they want to adhere to a treaty or not. So coming back to the concept of neutrality, in an armed conflict, a neutral state is any state not itself in any substantial way a party to that conflict, so a third state. Now, that sounds very nice in theory. Unfortunately, of course, the reality of neutrality is that we're not talking about a simple dichotomy. I'm sure that many of you, when I was discussing neutrality, were thinking about Ukraine. Is the US still a neutral state if it allows the Ukrainian military forces to use a US private operator satellite system, including for military operations, when clearly it doesn't allow the Russians to do so? Is that sufficient of a participation on the US part in the armed conflict, which is basically still between Ukraine and Russia, to make the US no longer a neutral state or not? And in today's globalized environment, it is almost impossible for states to have no ties whatsoever with one or the other, and probably with both. I already said that the US, in spite of everything, is still working with Russia on the space station. Now, that's really the exception. There's one other exception, I believe, but that's basically what it is. But it is almost impossible to cut all ties. So complete neutrality is basically a utopia. All neutral states are neutral, but some states are less neutral than others. And I think the best way to approach this is to say that neutrality is a kind of a bundle of sticks. Neutral states have a bundle of rights, and not to be attacked by any of the belligerents, not to see their economy harmed, not to be taken to task for trading with the opposing partner. And they may lose some of those rights if they do not behave as a true neutral, but they still might not lose their neutral status. And it's the law of armed conflict which determines those rights in quite some detail. Unfortunately, so far, however, only in the non-space domains. Now, this gives rise, and I apologize beforehand for the oversimplification, for a matrix of prioritization. So the first part is between belligerents and belligerents. Now, that's clear. Basically, LOAC supersedes space law. Between the belligerents, you don't have to pay for the damage you cause to another belligerent satellites. You don't have to treat the astronaut of another belligerent as an envoy of all humankind if he or she is clearly engaged in military activities. There's a sub-ranking in the sense that the UN Charter goes under number 1 above everything else, but LOAC is, as applicable per the structural principles of space law, superseding the substantive rules of space law. And then any other treaty law in line with the party intentions, as long as it's not manifestly absurd or unreasonable. So the substantive rules of space law only apply between belligerents as long as not superseded clearly by specific rules of LOAC. Now, the other easy part is, of course, neutrals versus neutrals, or third states versus neutrals. Here it's clearly the opposite. the UN Charter, and then the other rules of space law clearly supersede whatever the LOAC may say about neutral states. The problem is, of course, in the two areas that I left blank in this slide. And of course, they are identical. Here, we should accept that the UN Charter has this superior status. So as long as the UN Charter can be deemed to apply, and the LOAC following it from it, that the law of armed conflict, the rights to use force or defend yourself against the use of force, are still ruling supreme. So once you can argue that your country is attacked by a satellite, then your right of self-defense clearly springs into operation. The second is what I call the erga omnes rules of space law. There are certain rules on space law, which we will come to some examples, which do not just apply between pairs of states, but apply to the whole community. And that's where I would argue you cannot justify destroying something from an opponent if you also destroy something of third states who are neutrals. You cannot cause harm to neutrals. Then follows again LOAC on neutrality, non-erga omnes substantive space law, and the rest of treaty law. So to give you a little bit more of an idea, going back, yes, belligerents can damage or even delete or destroy the satellite of another belligerent, but any damage that is resulting to third states, they still have to compensate. There, the liability, of course, completely applies. And going back to this slide, that is the erga omnes rules of space law. You can't justify destroying the satellite of a neutral state, a third state, by saying, well, that's part of the hey, bad luck. We are fighting a war or an armed conflict with another state, and you just happen to be in between. No, you still have to compensate. Likewise, astronauts of third states should still be treated as envoys of humankind. When it comes to 5 and 6, belligerents are not required to provide detailed information on registered space objects. But that is not so much because this is not an obligation erga omnes, because it is, but the obligation is limited to general function and as soon as practicable. And that, unfortunately, to some extent, opens enough legal loopholes for a state to either not register a military satellite at all, because as soon as practicable could be argued to mean never, because I as a state do not consider it practicable to give you all the details about my military satellite. Or if you're a little bit less cynical, you can say the general function is remote sensing or is something like that, and not explain that it's military remote sensing, that it's spying, reconnaissance. And in any event, the liability as a launching state
Dear Professor, can you hear us?
will be clear erga omnes obligation, which is not overruled by the law of armed conflict, that you are allowed to cause damage to your opponent's military object. This is an erga omnes obligation, and the moon and other celestial bodies are the province of all humankind. So with that, I come to my concluding remarks. To the extent that LOAC is not addressing these issues in accordance with the matrix, we are still left with many questions. The main specific LOAC for outer space may unfortunately need to be developed to honor the general idea behind LOAC, namely to limit as much as possible unnecessary suffering and unnecessary spreading of violence. And the applicability of these non-domain specific LOAC principles, I think about proportionality. What does it mean in the context of a satellite? Can you destroy a satellite if one of the 10 channels is used for military operations, or only if all 10 of the transmitters are used for that? What is military necessity there? It needs to be clarified. Now, luckily, we are working on it. I'm happy to say that, in particular, a colleague of mine, Professor Jack Beard at the University of Nebraska, is hugely involved in developing the WUMRA manual on the International Law of Military Space Operations, where we analyze the applicability of existing LOAC, these principles, to and or vis-a-vis the applicability of space law. What can we logically deduct from state practice and state opinion on that? We map the resulting gaps, and we should be very clear. We as experts, we may consider ourselves very smart and honest and impartial, but we cannot create international law. So the resulting gaps can only be mapped by us and pointed out. We can sometimes give suggestions as to how to logically and in the benefit of humankind fill them in, but ultimately it's up to the states to do that. Again, we can provide the most reasonable application, but the specific crossover, WUMRA is going to help, but it's probably not going to be able to solve everything, and we still need a lot of work in this area. So in that sense, I hope I won't be sounding too cynical, but there is enough space out there for all you people to become space lawyers and help us solve these issues. And with that, I thank you for your kind attention. And there should be somewhere the Greek word for thank you should be in there as well. Thank you so much.
We are thank you very much for this interesting lecture. It was a very difficult topic to approach. I think that our students took all the necessary information in order to have more clear thoughts on these difficult topics. And I don't know, is there any question?
I will look and open the chat box myself. No. Oh, I'm not sure if it is not legitimate targeting engagement of food supplies as part of logistics, as long as there is no collateral damage concerns. Well, you're right. Of course, in many respects, I sort of took a very short cut. If you look at military law, if the military supplies are if the food supplies are clearly meant to support military fighting units, then it becomes a different issue, because then you could argue that by taking out those food supplies, you directly minimize or limits the fighting power of your opponent. So that might present you a justification as of targeting those. But just the targeting of food markets or food supplies for the population is clearly not as such legitimate. Trying to starve the opposing population into submission, which unfortunately has sometimes been the tactic of countries engaged in a military conflict. As such, that's not the idea. But you're right. I should have been a bit more nuanced there. But that's, I mean, as Johannes said, it's such an incredibly complex topic that in many respects, I can only give you sort of the general sense of where the issues are and how to approach them, and hopefully some tools of understanding the potential conflicts. But a lot of these details have to be still worked out. I fully agree. Then there is a question: if two states have armed conflict on Earth, could this legitimately take to the same actions in outer space? For example, Ukraine versus Russia. I'm not sure what you mean with same actions. Same actions as using military force against the opponent?
Or maybe...
If that's... Yeah, sorry, go ahead.
Or maybe continue their missile actions on outer space, or attack satellites. What do you mean?
That's a good question. And I think we should separate. I mean, most of the missiles that are fired now, as far as I know, I mean, I obviously don't know all the details, probably no one knows, but I guess all the missiles fired now are pretty low flying. So they fly through Russian airspace and then hit somewhere in Ukraine. And there may have been some vice versa actions. There's already Ukrainian drones have attacked certain military targets in Russia. That is, of course, not space because it doesn't even go to the altitude of outer space. Now, if ever Russia would start employing missiles that actually go through outer space, then unfortunately it's not space law which prohibits them from doing that, because as I indicated, Article 4 of the Outer Space Treaty only refers to the prohibition of stationing nuclear weapons. What is prohibiting the Russians from doing that is part of the fact that it is part of an unjust war. It's aggression under the UN Charter. And that, of course, prohibits all the military activities that they do in that point. But you should then distinguish between what they do in the context of this military conflict, whether that even fits into the right of the law of armed conflict or not. And it's interesting to note that the Russians at least always try to argue that what they're doing is still fitting in the law of armed conflict. And of course, they are basing themselves on the assumption that their use of military force is legitimate, whether they call it war or not. I hope that's kind of an action. Sorry, that's kind of an answer to your question, because shooting down a satellite, that brings in the other issues. You may be entitled, if it's really a military target, according to proportionality, to shoot down a satellite. But if you go to the origin and say, well, the military action by Russia is illegitimate from the start, then of course also shooting down satellites of the opposing party used in self-defense is part of that illegality. Can you elaborate whether the Chinese balloon was a hostile act, since it argued that it was a satellite balloon for science purposes? I'm not saying that it wasn't a spy balloon. No, that's a fair question. Of course, we don't know the details. Only the Chinese themselves who sent the balloon and the Americans who have investigated that can give you a real answer as to whether it was a spy balloon or not. What is clear is that the intrusion of the balloon into US airspace as such was a violation of US airspace. What the Chinese should have done, certainly if it was an innocent weather balloon, was not after the fact said, oh, sorry, yeah, this happened to be a balloon which went, you know, out of our control, and we never meant it to do that, etc., etc. They should have warned the moment that that balloon would have been close to entering US airspace, which is 12 miles offshore, because the US national airspace extends to over territorial waters. They should have said, they should have warned the US saying, I'm sorry, there's a balloon which, because of the wind, has lost control, blah, 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 is entering your airspace, so that the US could at least take any measures they want, whether it's to protect their own military secret or whether it's to protect maybe aviation, although I understood that this balloon was flying so high that it never was a threat to aviation. That the US would be entitled to say, well, sorry, but this is no good. So to me, the fact that the Chinese didn't do that tells me that they hoped that it would go along as unobstructed, unobserved, as long as possible, and that it was a spy balloon. Otherwise, they could have prevented it from shooting down. And it's very interesting to hear the Chinese reaction. They didn't say that the Americans were not entitled to shut it down. They just said it's an overreaction, like, oh, it's an innocent balloon. Why are you going to shoot it down, right? Now, I'm sure that one of the reasons why the US didn't shoot it down earlier is, I assume, but that's my assumption, they had already for a longer time, they knew what was going on, but they also wanted to see what was it doing. Can we distinguish, can we find out something of the technology that they're doing? What radar signals are they sending out to get information? What are they flying over? So that's why I think they shot it down at the last possible moment when it was about to leave US territorial waters on the other end. But strictly speaking, as long as a United States, you can argue that by shooting down a balloon, you don't kill anyone because it was an unmanned balloon, and you don't your action does not result in unnecessary danger to humans on the ground. You are perfectly entitled to do that. There's a clear distinction, for example, and again, most of you are far too young, but 40 years ago, the Soviet Union shot down a Korean airliner, which had a civil airliner, Korean Airlines, with hundreds of people on board, which strayed too much into Soviet airspace. And the Soviets originally tried to warn the aircraft, you're entering Soviet airspace, go back, turn around. Then they wriggled the wings of their fighter jets, which is an international symbol, go down. You need to immediately land because we want to investigate that you're not secretly under the guise, because there was a lot of suspicion in the Cold War days between the US and the Soviet Union that the Soviet Union, or that the United States was using a civil South Korean airplane as a ruse, and secretly would have put a lot of military reconnaissance information or instruments in the belly of the aircraft. And South Korea was, of course, a close ally of the United States to find out all sorts of things. And then when the aircraft didn't do that, they shot it down. And that was clearly not allowed, because by doing so, even though the airliner had intruded sovereign Soviet airspace, you killed hundreds of innocent civilians. Even if there might have been some truth to the accusation of the Soviets. Nobody knows. That's all top secret, of course. But of course, with a balloon, there's no question about it. Sorry, it's a long answer, but it's a very interesting question. Yes, Antonios, I agree. China wanted to check US counteractions on that, and at the same time, whatever information they could glean on the reactions on the ground would be helpful, because it also tells them what would happen if we send a military balloon over in case of a conflict. So that's clearly all part of it. I agree.
So it seems that there are no questions left.
Okay.
We would like to thank you, Professor Frans, again, and it is a great honor to have you here for the second year. And
thank you.
I think we'll have to renew our appointment at the summer course in July.
I'm hoping for that, yes.
And we'll be very glad to have you at this summer course again.
That would be nice. Thank you very much. All the best with your studies. And maybe I see some of you in the summer in Thessaloniki. That would be great.
Of course. Our students are invited to be there, so we have the opportunity to have maybe more useful conversations vis-a-vis.
I'm looking forward to that. Thank you very much.
Well, thank you.
Thank you. Bye-bye.
For your presence. Bye.
Bye.